Hi, I'm Robert from Legal Wise Seminars, and I'm here with Gary Newton, who's just finished presenting at our Practical Guide to Critical Conveyancing Issues. He's given us a case update on all the major cases, and right now he's going to speak about one of those major cases.
Thank you, Robert. Only last month, in the New South Wales Supreme Court, the judge handed down a decision concerning a termination of a contract. And it was an interesting decision because often when you get to completion of a sale, it might be that you haven't cleared the land tax or done something else, and you're going to do it through the PEXA settlement system. But unfortunately, with the wording in the contract based on the 2018 edition, which required the purchaser to hand over to the vendor an uncleared or a land tax certificate with a charge outstanding, then the vendor had the obligation to give back a cleared land tax certificate on or before completion. But unfortunately for that vendor in that case, they said they would settle on the PEXA system, they would get the money from the purchaser and use it to clear the land tax charge. Now, the trouble with that is that when they terminated the contract later when the purchaser didn't settle, they hadn't actually followed what they said they would do in the contract by delivering this clear land tax certificate on or before completion. So Justice Stark in the Supreme Court basically said they were not ready, willing and able. And even though there were a lot of other arguments about things like foreign resident capital gains withholding clearance certificates, or illegal building works, or failure to give figures, or not doing things, or even following the clause 30 on the PEXA steps, these were all things in the contract or conveyancing matters. But as to whether you're ready, willing and able, you need to look at what happens on completion, and by not following what was in the contract, the vendor was not ready, willing and able and shouldn't have terminated the contract, and so the purchaser was able to get an order for specific performance and thereby be able to go ahead and buy the property. And now that was an interesting case because since then the 2019 edition of the contract has changed that clause 16.6 and it now actually just says to put the position or get to the position where a clear certificate might be available. And that is basically what ended up happening in facts of a case after the edition of the contract was already printed, because everyone could see that it was impossible under PEXA to get a clearance for land tax before settlement. And in fact, if you pay it in PEXA, it doesn't actually clear for several days afterwards. So it was actually a problem we knew would come.
Right. Thanks for that, Gary. That shows that, it's a constantly changing area of law and conveyancing, so really good to hear the details of that case. Thank you.
You're welcome.